Welcome to Las Vegas Business, Bankruptcy, and Construction Law Podcast.
Hello, everyone, and welcome back to the Las Vegas Business, Bankruptcy, and Construction Law Podcast with Micheal Brock of Brock Law Group. Michael's a business and bankruptcy attorney who works with companies across Nevada facing financial pressure, debt issues, and complex disputes. With a background in both law and business, he helps his clients understand their options and make practical decisions when things get difficult. My name's Sean O'Connor, and today Michael and I are talking about what happens to personal guarantees when a business fails. Michael, good to see you.
Nice to see you, Sean.
I think personal guarantees are a pretty common thing in the small business world. What happens, when a business owner signs a personal guarantee? What are they actually agreeing to in practical terms?
Sean, in practical terms, a personal guarantee is the owner saying, if the business can't pay this debt, I'll pay it personally. So you're agreeing to stand in the shoes of the borrower, often the business, if things go wrong. The business owner is converting business risk into a personal financial risk. So if the business shuts down or it goes bankrupt or has no assets, the creditor is going to come after the owner personally to collect what's owed, and it will mean that the owner's personal assets will be at risk.
Okay. Simple, but not easy to deal with, I guess.
Sure.
So I'm running a business, it starts to fall behind, right? And I'm aware I've got some personal guarantees out there in the financial ecosystem. At what point do those guarantees begin to matter in a real way?
Yeah, that's a great question. Personal guarantees are there from day one. Once you sign it, it's in place. But they don't generally become real in practical terms until the situation crosses over from one of manageable stress to actual default and enforcement risk. Early on, the guarantee is kind of in the background. It's risk, but it's not really, it's in the background. You don't really think about it, maybe, or you're not conscious of it. But later, it becomes that creditor's primary leverage against the owner. When those first defaults start to hit, that's when the personal guarantee really starts to matter. Then the creditor's primary source of repayment shifts from the business to the owner.
Yeah, I get it. Like, it's a very common clause, I think. And so it's just part of the cost of doing business, so to speak. I don't want to say boilerplate in any agreement, but, because obviously it's a serious thing. But I think there's a certain, there can be a cavalier attitude to, I'm going to have a personal guarantee. We're not going to fail. It's not going to be an issue. But I'm curious, there's a difference between having a personal guarantee and actually acting on it as the creditor, right? What causes a shift in that? Because it's like, oh, everything's fine. You're like, now I'm going to call in my chip, so to speak.
Yeah, it's usually the result of a shift in expected recovery by the creditor, and if they lose confidence, in the business. So creditors will enforce the guarantee when they stop believing that the business is going to be able to repay the debts. Mm-hmm. And so they decide that the guarantor is really going to be the best or possibly even the only way to recover.
I'm curious about, again, I'm sure it depends on the nature of these businesses and how closely, in communication they are. But how does the creditor make that call? Is it simply, listen, the payment history is X, or I'm getting a vibe that they're not going to be able to pay, or is there data available, so to speak, where they can analyze, like, okay, this isn't going to pencil out, because it's not like they're really in the business's books, are they? Or maybe they are.
Not so much into the business's books. They're really probably just monitoring, are payments being made on a regular basis? Are they being made late? How frequently are they coming in late? Are we missing payments? So those are the kind of things that the creditors are mostly monitoring to see, how the health of the business is, and that's how they're going to really be able to determine whether, they think the business might be in a position where it might be time to look at the guarantee as the way to collect what's owed.
Yeah, and it makes sense. And a lot of, I'm thinking like, your a bank. They've seen the movie before. Like, oh, okay, there's certain patterns and behaviors and trends that are not unique, I'm guessing. So we shift right now. The guarantee is going to be enforced. How does that situation unfold for the individual owner who has personally guaranteed the debt or the loan?
So once that guarantee is enforced, then the situation is really going to shift from a business problem to being more of a personal, legal, and financial problem for the owner. What we typically see is that the creditor will start out by sending a demand letter to the owner. Sometimes there may be some attempt to negotiate between the creditor and the guarantor, the business owner. But if those options fail, then you're going to see that creditor filing a lawsuit to try and collect. And then assuming that creditor is able to obtain a judgment against the owner based on that guarantee that was given, they're going to start making efforts to collect on that debt. They might try levying the bank accounts of the owner, or they may try to garnish the owner's wages if they've started working in a new job. It's possible they may even place some kind of a judgment lien on real property that the owner owns. So that's kind of the progress that we see happen, in this when they start to enforce that guarantee.
Right. I'm in the construction business, and maybe I own some heavy equipment, and like they put liens on that, or force me to sell it, I guess, for cash payments and what have you, because obviously the bank doesn't want a tractor, but they want the money from the tractor.
Yeah, absolutely. Yeah, they may try and force some kind of a sale or foreclose on that judgment lien to be able to collect the money. Sometimes it's possible, even after judgment's been entered, there may be some ability to negotiate to try and get that resolved, in a more favorable way, so you can avoid those collection efforts. Yeah. But if you're not able to negotiate, then that's basically what you're going to face as a business owner.
So I don't say worst case scenario, but kind of, okay, so now, the enforcement is underway. The personal exposure is there. I'm a business owner under a lot of pressure. What's the decision making that you see? I'm assuming, like, mistakes get made, or the business is impacted in some other ways, or the individual is impacted.
Yeah, knowing that that's the outcome that you're likely to face if things don't go well, and they start to enforce that personal guarantee, it is going to shape how a business owner thinks and how that business owner acts. Pressure is building, and decisions very naturally start to shift from what's best for the business to what protects me personally. So risk tolerance changes. Cash decisions become personal decisions, and owners will very often start making more defensive, short-term, and personally protective decisions when that pressure starts to build.
Is there a place where business owners tend to underestimate the impact of a personal guarantee?
I think that most business owners understand in a general sense that a personal guarantee is serious.
Yeah.
But where they may underestimate it is in how broadly and how quickly it affects their situation once things go sideways. So, owners might assume that a creditor will go after the business first if things aren't going well. But what they may not understand is that many guarantees allow a creditor to pursue the guarantor immediately. They don't necessarily have to go after the business first. They can go after that guarantor first. Wow. And so it becomes, again, a personal financial problem the moment that those guarantees become relevant. Owners might view the guarantee as a contingent risk, while the creditor is looking at it as a real enforceable asset against the business and the owner.
We had spoken about restructurings, bankruptcy as a tool for businesses to use, and I'm wondering how personal guarantees interact with bankruptcy. Both from the business side and from the individual side.
They can be, and they probably should be when you're in a situation like that, because The business's bankruptcy and the individual owner's liability are legally separate matters, separate issues. More simply put, a business bankruptcy doesn't eliminate that personal guarantee. Only the individual's bankruptcy can do that. So business bankruptcies deal with the company's liabilities, and an individual bankruptcy will deal with the owner's liability under the guarantee.
Let's talk timing, because timing always comes into play in these things in terms of, keeping your options open and that sort of thing. You know, Someone's dealing with both business debt and personal exposure. What's your advice to them about, how quickly to act, or when is it best to wait things out, or other angles?
Yeah, that's a good question, Sean. So, you kind of asked me a little bit earlier, should these things be, with the guarantee and the business bankruptcy, should those things be working in tandem? And the answer is yes, they often should. It's important to try and kind of synchronize those two things, because, again, as we've discussed previously, the best outcomes happen when you act early and when the business strategy and the personal risk strategy are addressed together. Acting on those things early and deliberately will often lead to the best outcomes. So if you wait until the business outcome is clear, then the personal outcome is often going to be constrained. So it's important to try and work together to deal with, the business issues and that owner's personal liability issues so that you can have a good outcome.
Is there a scenario where you can have the personal guarantee? I'm talking about sort of pre-crisis, I guess, here. Everything's going well. My business is functioning. I'm paying my bills. I'm paying my people. Is there an opportunity to remove a personal guarantee from the terms of engagement, so to speak? Or is that like a refinancing situation? Or
In my experience, that's a really difficult thing to do because the creditor is, again, as we've talked about, that's some real leverage that the creditor has, and that's their security. And so they tend to be very reluctant to give those things up. There may be some circumstances where you may be able to persuade a creditor or a landlord, for example, to waive or release any kind of personal guarantee.
yeah,
But
you
in my
probably need to
experience,
trade it
it's
for
really
something.
uncommon. Yeah.
You need to trade it for something, I don't know.
Yeah.
Lottery tickets. No, I'm kidding. Uh, let's just say someone puts it off. They don't open their mail. They're procrastinating. They're too optimistic, and they've waited too long to address the personal guarantee situation. We were talking about options earlier. What tends to change for that person now in terms of options that are available?
Yeah. I mean, I've kind of mentioned this before. I don't want to sound like I'm repeating myself, but it's not just that there are fewer options, but the nature of those options will often shift from being ones that are flexible and negotiated to being much more rigid and imposed by someone else. So early action will allow you to have more control over shaping the outcome, while that later action will lead to more reaction than outcome. So you might have to move from maybe having choices to instead having constraints. Again, the best outcomes are generally those where you act early, and generally where you start taking action before enforcement on that personal guarantee begins.
Just with the couple minutes we have left, I'm wondering, because I talk to attorneys all the time, right? And the law's the law, the contract's the contract. The problem is we're dealing with people, right? And there are scenarios, and this may or may not be one, and it probably depends, but the importance of the personal relationship, and like you had mentioned in an earlier conversation, a creditor is like, okay, these guys aren't being straight with me anymore. And then, like as a human, if you're lying to me, I'm less likely to cut you some slack, right? So would you advise people? I mean, I'm not an attorney, but, like I'm thinking of probably a lot can be done on a personal level to, keep things from getting to that extreme. Like, all right, we're invoking the personal guarantee and we're going after your house. I mean, is that otherwise? Because I think people maybe sometimes hide from the problem, literally or metaphorically, and then it ends up worse than it would have been.
As an attorney, and I think this is probably true for attorneys in general, a lot of times when people come to talk to us and see us, it's because they've waited until a problem has become a crisis. And so they're looking for help, whereas if they had taken certain action maybe a little earlier, they could have avoided the crisis. I mean, it doesn't necessarily mean the problem goes away, but maybe it could have been dealt with in a better way. And so, yes, again, I think, being open and honest, transparent, communicate with your creditors. I've had a client who, this is rare, but I do have a client who, was facing some financial situations and made that decision to try and address them earlier. And, we've communicated with creditors for that client. We've explained the situation. There is the possibility that his situation is going to improve. I think we've been able to demonstrate that. And it seemed like the creditors appreciated that and they were willing to work with us. So having that personal relationship, I think, communicating with your creditors, being transparent as you possibly can with them, I think it's going to help resolve situations in a much better way, so before things become a crisis and then becomes a legal situation rather than just a financial situation.
Yeah, I mean, there's a point where it's not personal. We just need to get paid back. But
absolutely, yeah.
It can, in a good way, be personal at first. So
yeah.
Anyway, Matt, thanks for speaking to that. We are out of time, but I suspect we will talk again soon.
Looking forward to it, Sean. Thank you.
That's it for today's episode of the Las Vegas Business, Bankruptcy, and Construction Law Podcast. If you'd like to learn more about Micheal Brock and how he helps Nevada business owners navigate financial pressure, debt, and bankruptcy decisions, visit the website maybrocklaw.com. Thanks for listening. I'm Sean O'Connor. Do us a favor, leave a review, a thumbs up, subscribe to the show, share a link with a colleague who you think might benefit from this kind of information. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.